claimants, and the National Governing Board acted thereupon to approve the claimant's dismissal. The first complaint of the claimant is with respect to the NYSC Condition of Service, Revised Edition 2013. Her case is that the condition of service is illegal as it was not made by the President or by the Directorate, and the defendant did not receive the approval of the President to make the condition of service. On the basis of this complaint, the claimant sought reliefs 1 and 9, wherein she has asked this court to declare the condition of service illegal, null and void, and to set aside the condition of service. It is, however, strange that the claimant, who has put the condition of service in issue and wants this court to set it aside, has failed to produce the document before the court. The court is not a magician, and it cannot therefore consider a document or make orders relating to a document unless the document is before the court, except where what the court is called on to construe or consider is a statute, law, or any instrument which the court can take judicial notice of. A party who seeks the court to make an order on the basis of a document must produce the document before the court. This is so because without the court having to examine the document, it cannot properly determine or make an informed decision on the document. By failing to produce the condition of service before the court, the foundation of her claim in reliefs 1 to 9 is clearly missing. It was the defendant who assisted the claimant's case by producing the NYSC Condition of Service Revised Edition 2013 in evidence through DW1. The document is Exhibit NYSC 9. Since the document is in evidence, I will examine it to determine the suit of the claimant. It is clear that there exists in the defendant a condition of service called NYSC Condition of Service Revised Edition 2013, and it was used in the disciplinary action taken against the claimant, resulting to her dismissal from service. The reason the claimant said the NYSC Condition of Service is illegal is that it was not made by the President or the Directorate, contrary to the provisions of the NYSC Act. In other words, it is the contention of the claimant that the condition of service of the defendant must be made by the President or the Directorate for it to be valid and applicable to the claimant's employment. The claimant, however, failed to mention the law, statute, or instrument which requires that the condition of service of the defendant must be made by the President or the Directorate. I have examined the NYSC Act, which established the defendant, in order to find if it contains any provision which supports the assertion of the claimant. The provisions therein which are relevant to the issue in contention are in Section 16 of the Act. Section 16, subsection 1, provides that the President may make regulation for the purpose of achieving the objects of the Act. By this provision, the regulation which the President is empowered to make under the Act is with respect to the objectives of the Act. The objectives of the Act, in respect of which the President can make regulation, are set out in Section 1(3) of the Act of the NYSC Act. A careful examination of the objectives of the Act reveals that they do not include employment or service in the defendant. Therefore, the regulation which the President is empowered to make in Section 16(1) of the Act does not extend to regulation or condition of service for the employees of the defendant. Section 16(2) of the Act empowers the Directorate to make, for the proper administration of the service corps, with the approval of the President, bylaws. First of all, what the Directorate is empowered to make in Section 16(2) is bylaw. Secondly, the bylaw is one made for the proper administration of the service corps and not condition of service of employees of the defendant. Thirdly, the document in issue contains the terms and conditions regulating the employment of employees of the defendant. It is not a regulation which the President may make in Section 16(1) of the Act or a bylaw, which the Directorate may make, with the approval of the President in Section 16(2) of the Act. In my view, Section 16 of the Act, NYSC Act, does not contain any provision which confer power on the President or the Directorate to make a condition of service for the employment in the defendant. I am unable to find any provision in Section 16 of the NYSC Act which requires the President or the Directorate to make condition of service for the employment in the defendant. Furthermore, I cannot find any provision in the Act which requires the approval of the President to validate a condition of service made by the defendant. The Act did not also prescribe who can make or how a condition of service can be made for the service in the defendant. The defendant pleaded that the defendant is empowered by the public service rules to have a condition of service for his employees. This averment was not controverted by the claimant. In the final written address of the defendant, learned counsel for the defendant referred to the provisions of rules 160103 and 160404 of the PSR and submitted that the NYSC condition of service draws its authority from the public service rules, and it gives the condition of service its legitimacy. It strikes that the PSR was made pursuant to powers conferred by the Constitution. For this reason, the PSR has been regarded as a subsidiary legislation and has the force of law. See Federal Civil Service Commission versus Laoye, 1998, Federal University of Technology, Yola versus Mewuya, 2013. The following provisions of the public service rules are instructive. I have set out the provisions of Rule 160101, 160103, 160501. They have been copiously set out in the body of the judgment. The above provisions of the PSR define the establishments to which it applies. The defendant, being a government agency established by statute, is a parastatal under Rule 160101 of the PSR. Accordingly, the PSR is applicable to the defendant. Rule 160103 gives the defendant the liberty to make its internal condition of service, made in line with the general principles contained in the PSR to regulate its employment. But in the absence of an internal condition of service, the provisions of the PSR shall apply. By these provisions, the defendant is empowered to make a condition of service for his employees and to apply same in the discipline of his employees. In view of the silence of the NYSC Act on the making of a condition of service in the defendant, it does not mean that the defendant, being a statutory body, cannot make a condition of service to regulate employment in its service. The defendant is permitted by the PSR to make a condition of service. Thus, any condition of service made by the defendant pursuant to the enabling provisions of the PSR is valid, lawful, and legal. Consequently, I do not find merit in the allegations of the claimant regarding the making or the validity of the NYSC condition of service, revised edition 2013. The claimant has also not advanced any cogent reason to convince me to nullify or set aside the NYSC condition of service, revised edition 2013. Other complaints of the claimant are that both the NYSC Senior Staff Committee, which indicted her, and the National Governing Board, who approved her dismissal, are unlawful bodies. These complaints are based on her allegation that the NYSC condition of service, which created the NYSC Senior Staff Committee and the National Governing Board, is illegal. It will seem that these complaints of the claimant are no longer valid points for consideration. In view of the finding in this judgment that the said NYSC condition of service is valid and legal, nonetheless, there's need to examine the allegations of the claimant in details. The contention of the claimant is that only the Directorate has the power to discipline her or terminate her appointment. According to the claimant, the National Governing Board, who took the decision to dismiss her, does not exist as a body in the defendant and cannot approve the dismissal of the claimant. On the other hand, the defendant averred that the Directorate has a governing board, which is an integral part of the Directorate, and the board is appointed by the President to undertake all the functions of the Directorate, which includes appointments, promotion, and discipline of staff of the defendant. According to the defendant, the governing board is one and the same as the directorate. The issue here is whether a body known as the National Governing Board exists in the defendant, and whether such body, if it exists, has the power to discipline the claimant. To resolve this issue, I have to examine the provisions of the NYSC Act again. I find the following provisions in section 3, 1, 2, and 3 of the Act. 1, there shall be established a national directorate, in this Act referred to as the directorate, which shall be the governing body of the service corps. 2, the directorate shall have a governing board, which shall be comprised of the following 10 members to be appointed by the president. 3, a member of directorate, other than an ex-officio member, shall hold office for a term of 3 years from the date of his appointment and shall be eligible for appointment for one further term only. Section 4.4 of the Act provides that the directorate shall have power to appoint, advance, terminate, and discipline employees holding or acting in any office in the directorate. From the provisions of Section 3 of the Act, a directorate is established for the defendant as the governing body of the defendant. The directorate has a governing board of persons appointed by the president, and these persons or members of the governing board, as stated in subsection 3, are the members of the directorate. In essence, the directorate is comprised of members of the governing board. In other words, the directorate and the governing board are one and the same. I have also seen the definition of directorate and membership of the directorate in section 22 of the Act. And it is clear to me that there is no distinction between the directorate, membership of the directorate, and governing board. In my view, therefore, any reference to the directorate is a reference to the governing board. Also, acts of the governing board are the acts of the directorate. Thus, when in section 4, subsection 4 of the Act, the power to discipline employees of the defendant is vested on the directorate, it implies that the governing board, who is the human persons, just want to be sure that my internet is who is the human persons comprising the directorate is the body who statutorily exercises that function. Therefore, I do not find merit in the claimant's allegation that the governing board does not have power to discipline her. Without a doubt, the decision of the governing board of the defendant communicated to the claimant in Exhibit NYSC 3 is the decision of the directorate. In Relief 2, the claimant sought to be declared that the NYSC condition of service cannot establish bodies known as the NYSC National Governing Board and NYSC Senior Staff Committee in the defendant with power to indict, discipline, or dismiss the defendant's employees. I have examined the content of the condition of service, but I cannot find where the NYSC National Governing Board was established in the condition of service, or where the NYSC National Governing Board was specifically given the power to indict, discipline, or dismiss the defendant's employees in the condition of service. The extent to which the NYSC National Governing Board was mentioned and used in the NYSC condition of service is in the definition section, where the directorate was defined to mean NYSC Governing Board. I have held in this judgment that the directorate of the defendant established in the NYSC Act is the same as the governing board. Thus, when the condition of service defined directorate to mean the NYSC National Governing Board, it cannot be interpreted as done by the claimant to mean that the condition of service established a new body known as the National Governing Board. The directorate and the governing board are one and the same body under the Act, and the powers of the body with respect to discipline of employees of the defendant has been set out in the Act. Whether or not the condition of service mentions or stipulates the body who can discipline staff of the defendant is therefore irrelevant. Perhaps the reason the claimant alleged that there is no such body as National Governing Board is the fact that the NYSC Act refers to Governing Board and not National Governing Board. The claimant's complaint may be because of the addition of the word national to governing board. If this is the reason for the complaint of the claimant, that there is nobody known as national governing board exists in the defendant, then I will straight away I will straight away dismiss the contention in view of Section 3(1) of the NYSC Act. This provision established a national directorate to be the governing body of the defendant. This provision implies that the directorate can also be called national directorate, and the governing board, which is also the directorate, can also be called the national governing board. In my view, whether called governing board or national governing board, the name refers to the same body. Thus, the fact that the word national is added to governing board does not mean that it is a non-existent body. Now, to the claimant's averment that the SSC cannot sit over her matter or indict her, this aspect of the case of the claimant, as I have said earlier, is also based on her assumption that the NYSC condition of service was not valid. This part of the case of the claimant has been resolved earlier in this judgment, when it was determined that the claimant did not show that the NYSC condition of service was not properly made, nor did she give any reason to invalidate or nullify the NYSC condition of service. The implication is that the committees or processes set up in the NYSC condition of service are lawful and valid. Accordingly, the provisions of the NYSC condition of service are binding and applicable to staff of the defendant, including the claimant, during the subsistence of employment. I have seen Section 2.11 of the NYSC condition SSC was set up to handle the appointment, discipline, and promotion of officers on grade level 7 and above. In view of the foregoing, I do not find merit in the allegation of the claimant that the SSC cannot sit over her case or indict her. The claimant also averred that her dismissal from service was with retrospective effect from 31st October 2020. She said the letter of dismissal is dated 25th January 2022, and it was delivered to her on 1st February 2022. The claimant contended that the defendant cannot backdate her dismissal from the employment. I have seen the letter of dismissal. It is dated 25th January 2022. In paragraph 2 of the letter, the claimant was informed that you are hereby dismissed from service with effect from 31st October 2020. It is obvious that the claimant's letter of dismissal was issued in January 2022, but her dismissal was made to date back to October 2020. I agree with the claimant that the defendant cannot dismiss her retrospectively. The content of paragraph 2 of the letter of dismissal discloses that the governing board of the defendant had its third ordinary meeting. It was in that meeting that it approved the dismissal of the claimant from service. Thus, the dismissal of the claimant cannot take effect earlier than the date the approval was given. I must add that the fact that the claimant's dismissal was made retrospective does not affect or invalidate the dismissal. The position of the courts when they find that disciplinary punishment is made retrospective is to take the date of the disciplinary punishment from the date it was awarded or the date notice of same was given to the staff concerned and no more. See Underwater Engineering versus Daru Adubefon, 1995. See also New Nigeria Bank Limited versus Francis Obefudiri, 1986. In this case, notwithstanding the fact that the letter of dismissal mentioned that the dismissal was with effect from 31st October 2020, the actual date of the dismissal of the claimant was the date the decision to dismiss her from service was taken. In Relief 6, the claimant complained of wrongful dismissal. It is observed that the only reason she gave for alleging wrongful dismissal is her complaint about the legality of the NYSC condition of service. The NYSC National Governing Board and the NYSC Senior Staff Committee, upon carefully considering the issues raised by the claimant with respect to the NYSC condition of service, the NYSC National Governing Board, and Senior Staff Committee, I do not find any merit in her allegations, which allegations sadly formed the basis of her claims in reliefs 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, and 15. These claims have not been proved, and the implication is that the claimant failed to prove that her dismissal was wrongful. The claimant sought an order in relief 14
So, yeah, you cooking.
the defendant to immediately release her letter of my back.
Yes. Yes. Yes, Baba.
I hope you didn't lose me at all. So I will just, I'm about rounding up. Let me see. It is the case of the claimant that she sat for the promotion examination in February 2021, but her promotion letter was not given to her until she was dismissed in January 2022. Exhibit NYSC 5 is the query issued to the claimant
So,
on second February 2021 to initiate the disciplinary case, which eventually resulted to her dismissal. The defendant has pleaded that the claimant was not entitled to promotion because she had a pending disciplinary case. The claimant did not file a reply to the statement of defense. She did not challenge this averment of the deny the fact that she was not entitled to promotion. She did not deny the fact that she was not entitled to promotion during the period of the pending disciplinary case against her. The period the claimant claims she ought to be promoted was the period she was undergoing disciplinary case. For this reason, her promotion was not released up till the time she
so, mm,
Done.
Mm.
Right.
Ina ji. A'a ban jin tawo.
Can you speak English, please?
Sorry,
This is a
sorry.
courtroom. English, okay?
Okay, my lord.
Yes, ma'am. We're not hearing.
To what purpose will it be? Will it be to the claimant? If the court grants the claim for the release of the promotion letter, I think none. The claimant is no longer in the defendant's employment and she's not entitled to reinstatement to the employment. Her claim for release of her promotion letter is therefore the claim in relief 13 is in alternatives. In the principal claim, the claimant sought an order directing the defendant to pay her monthly salaries and honorarium of grade level 12 from January 2022 till she is reinstated, and other entitlements from the month of her dismissal. First, the claimant has not proved that she is entitled to promotion to grade level 12. Again, the salaries, honorarium, and other entitlements I have considered the suit of the claimant in details and examined all the relief sought by the claimant, but I do not find merit in the suit. All the relief sought by her have not been proved. Consequently, this suit fails and it is accordingly dismissed. No order as to cause. Judgment is entered accordingly.
As the court pleases. Thank you, my lord, for your time and consideration
Thank
in this.
you. Thank you. Sorry about the network. The network seems to be fluctuating. So I'm going to try to abridge the next one in view of the fact that they are almost the same. But let's see how it goes. Call
Okay,
the
my lord.
second.
Yes,
Yes.
ma'am. That- that 171 and national party.
Parties absent.
Yes, ma'am.
Appearances.
May it pleases my lord, my name's ML Augi. My humble appearance is for the defendant.
Your name is ML Augie, GIE or
Yes, madam.
Audi?
Augie, GIE.
Audi, GIE. Thank you. No, it's okay. And that belongs to that. ML Aogi for the defendant.
Yes, my lord.
No appearance for the claimant.
Yeah.
Okay, so just like the earlier one, I'm going to be reading directly from my system, and here
Okay.
is the judgment of the court. The claimant instituted this action via the complaint filed on 2nd June 2022. His claims against the defendant are as follows. Again, there are altogether 17 claims, out of which one of them, claim number 14, is an alternative claim. Starting from 14 is alternative claims. I have again summarized the case of the claimant and that of the defendant. I have touched on the written addresses, and I'll go straight to the decision. And the decision is essentially similar to the one I just delivered, but all the same, I'll still try to read portions of it that as may be necessary. From the facts of the case of both parties, it is not in dispute that the claimant was an employee of the defendant and that he had been dismissed from the employment. The claimant's employment letter is Exhibit NYSC 1, indicating that he was employed on 11 December 2006, while the letter of dismissal is Exhibit NYSC 3, dated 25th January 2022, and it states that the claimant dismissal was with effect from 31st October 2020. From the pleadings and evidence adduced by the claimant, he is dissatisfied with his dismissal and he has given some complaints against his dismissal. These are listed in this judgment from number 1 to 4. And in defense of the defendants, it is admitted the existence of the National Youth Service Corps condition of service, and that the defendant is empowered by the public service rules to have such a condition of service for his employees. The defendant also admitted that the senior staff committee is established by the NYSC condition of service. They explained, however, that the directorate, the governing board, and the national governing board are one and the same body with the power to dismiss the claimant or any erring staff. I have seen the dismissal letter. It discloses that the claimant was indicted by the senior staff committee, SSC, for extortion of corps members. And the National Governing Board approved the claimant's dismissal in line with the provision of the NYSC condition of service. The first complaint of the claimant is with respect to the condition of service. His case is that the condition of service is illegal as it was not made by the president. And he sought reliefs 1 to 9, wherein he has asked the court to declare the condition of service illegal, null and void. Strangely, however, the claimant who has put forward the condition of service for resolution has failed to produce the document before the court. The court, not being a magician, cannot therefore consider such a document relating to or make orders relating to such a document unless the document is before the court. By failing to produce the condition of service, the foundation of his claim in release 1 to 9 is missing. The defendant has, however, assisted the case by producing the NYSC condition of service. in evidence through DW1. It is Exhibit NYSC 9. I will examine it to determine the suit of the claimant. It is clear that the defendant that there exists a condition of service and it was used in the disciplinary action taken against the claimant, resulting to a dismissal from service. The reason the claimant says the condition of service is illegal is that it was not made by the president or the directorate, contrary to the provision of the NYSC Act. I have examined the NYSC Act which established the defendant in order to find if it contains any provision which supports the assertion of the claimant. The provisions which are relevant to the issue are in Section 16 of the Act, which provides that the president may make regulations for the purpose of achieving the objects of the Act. Thus, the regulation which the president is empowered to make under the section is with respect to the objectives of the Act. A careful examination of the objectives of the Act reveals that they do not include employment or service in the defendant. The regulation which the president is empowered to make in Section 16(1) does not extend to regulation or condition of service for the employees of the defendant. Firstly, what the directorate is empowered to make in Section 16 is bylaw. The bylaw is one made for the proper administration of the service corps and not condition of service of employees of the defendant. Thirdly, the document in issue contains the terms and conditions regulating the employment of employees of the defendant. It is not a regulation which the president may make in Section 16 of the Act, or a bylaw which the directorate may make. In my view, Section 16 of the NYSC Act does not contain any provision conferring power on the president or the directorate to make a condition of service for the employment in the defendant. I'm unable to find any provision which requires the president or directorate to make condition of service for the employment. Furthermore, I cannot find any provision which requires the approval of the president to validate a condition of service made by the defendant. The Act did not prescribe who can make or how a condition of service can be made for the service in the defendant. The defendant pleaded that the defendant is empowered by the public service rules to have a condition of service for his employees. This averment was not controverted by the claimant. In the final written address of the defendant, the learned counsel for the defendant referred to the provision of Rule 160103 and 160404 of the Public Service Rules and submitted that the NYSC condition of service draws its authority from the Public Service Rules, and it gives the condition of service, which gives the condition of service its legitimacy. It is right that the Public Service Rules was made pursuant to powers conferred by the Constitution. For this reason, the PSR has been regarded as a subsidiary legislation and has the force of law. See Federal Civil Service Commission versus Laoye, 1998, Federal University of Technology, Yola versus Mewuya, 2013. The provision of rules 160101, 160103, and 160501 set out here define the establishment to which they apply. The defendant, being a government agency established by statute, is a parastatal under the Public Service Rules. Accordingly, the Public Service Rules is applicable to the defendant, who has liberty to make its internal condition of service, to regulate its employment. But in the absence of such internal condition of service, the provisions of the Public Service Rules shall apply. In view of the silence of the NYSC Act on the making of a condition of service in the defendant, being a statutory body, it cannot make a condition of service to regulate employment. It does not mean that the defendant cannot make a condition of service to regulate employment in his service. The defendant is permitted by the public service rules to make a condition of service. Consequently, I do not find merit in the allegations of the claimant regarding the making or the validity of the NYSC condition of service. Revised edition 2013. The claimant has also not advanced any cogent reason to convince me to set aside the NYSC condition of the claimant and bodies. These complaints are based on the allegation that the NYSC condition of service, which created the senior staff committee and the governing board, is illegal. It will seem that these complaints are no longer valid points for consideration in view of service is valid and legal. Nonetheless, there is need to examine the allegations of the claimants in details. So I have analyzed the allegations and I come to the resolution. The directorate and the governing board are one and the same. I have also seen the definition of directorate and membership in section 22 of the Act. And it is clear to me that there is no distinction between the directorate, membership of the directorate, and the governing board. In my view, therefore, any reference to directorate is a reference to the governing board. Also, acts of the governing board are acts of the directorate. Thus, when in section 4, the power to discipline employees is conferred on the directorate, it implies that the governing board, who is a human person, persons comprising the directorate, is the body who statutorily exercises that function. I do not find merit in the claimant's allegation that the governing board does not have power to discipline him. Without a doubt, the decision of the governing board of the defendant communicated to the decision of the directorate. I established in the NYSC Act is the same as the governing board. Thus, when the condition of service defined directorate to mean NYSC National Governing Board, it cannot be interpreted as done by the claimant to mean that the condition of service established a new. I will straight away dismiss the contention in view of Section 3 of this Act. This provision established a national directorate to be the governing body of the defendant. It implies that the directorate can also be called National Directorate and the governing board. In my view, whether called governing board or national governing board, the name refers to the same body. Thus, the fact that the word national is added does not mean that it is a non-existent body. In view of the foregoing, I do not find merit in the allegation of the claimant that the senior staff committee cannot sit over his case or indict him. The body of this judgment is mainly the same as the one I read earlier. So, and they contain almost exactly the same thing. However, I chose to read clips and parts of it in view of. So I have considered the suit of the claimant in details and examined all the relief sought by the claimant, but I do not find merit in the suit. All the relief sought by him have not been proved. Consequently, this suit is dismissed. No order as to cause. Judgment is entered accordingly. So that will be it. Um, Can you unmute your mic so I can hear you? Okay, so I'm done. I'm done reading the judgments. I'm going to get them across to be printed so that you can have your copy hopefully by Monday. Well, I'm not able to hear you, I'm afraid. Since I'm done reading the judgments, I'll leave the meeting now.
Okay, my lord. Yes, my lord.